Hello, I'm Jessica Ryan Keeney. I'm an attorney licensed to practice law in the state of California. I practice primarily family law, and I am the Department of Child Support Services attorney for 2 small Northern California counties. Anything in this video or in the description or in the comments or that may be linked to is not intended to be legal advice. This is for educational purposes only. Go ahead and subscribe if you haven't already. Click the bell so that you get notifications when we upload new videos, and give this a like. Drop us a comment too. In today's video, we're going to discuss reply declarations. So this is seen in a few different situations, but the situations I see it most in are if somebody needs to reply to a response to a request for order, or if somebody needs to reply to a notice of motion. So in my private practice, I see this when a request for order has been filed in a family law case, and then the responsive declaration has been filed, and then the party who filed the request for order needs to add more information, object to something in that responsive declaration, or provide more information to the court. In my child support world, for the Department of Child Support Services, I see a reply declaration when we have filed a notice of motion, usually to modify child support, but sometimes it's for a seek work order or to add an insurance provision or something to that effect. And then either mom or dad file a response to our notice of motion, and then we need to file a reply. And in my departments, we usually file a reply when we need to recalculate the guideline child support, serve that new calculation on mom and dad, and get it filed with the court. And so the time frame to serve both the request for order or notice of motion and the responsive declaration and the reply are all covered in Code of Civil Procedure section 1005. And so for the reply specifically, it needs to be served at least 5 court days before the hearing. So to figure that out, we have the hearing date and then we count backward 5 court days. So I don't include the hearing date, I don't include weekends, and I don't include holidays. I don't include the court date because, well, that's the court date. And obviously weekends and holidays, the court isn't open. So what sort of other information can you put in that reply? Well, if you want to object to any hearsay or irrelevant information in the response, you can go ahead and do that in the reply. A lot of times in family law cases, I don't object to things that I could object to, simply because the information is going to come in anyway, and if I object to it being hearsay, then we're going to end up in an evidentiary hearing, calling witnesses, examining, cross-examining, and I'm fairly certain that the witness is going to say exactly what the other party said they're going to say. So it's a strategy thing. I have to work it out with my clients, and it's something that self-represented parties have to figure out for themselves. And obviously, if you have an attorney, you need to talk to your attorney about it. And it's just a completely different video, whether or not you should or shouldn't object to hearsay and irrelevant information in the responsive declaration or in the notice of motion or the request for order. But anyway, I'm off on a tangent here. So there you go. That's your reply. It's typically done on pleading paper. I've seen it done on the judicial counsel form that's called a declaration. Either one is okay. You want to make sure that you make it very, very clear what you are replying to. So let's say that DCSS filed the notice of motion, and then mom filed a responsive declaration, and now DCSS needs to file a reply. I would call that reply something to the effect of DCSS reply to mother's responsive declaration to notice of motion with court date, and then I'd list what the court date is. Now it's really clear where that reply goes with all of these documents filed in the court file. Sorry for hitting my mic. I might not be able to edit that out. If it's a private family law case, I'm going to title my reply very similar. Now you need to make sure that once you draft your reply and you get it served on all of the parties, you do a proof of service and you file with the court your proof of service for having served the reply and your reply. Remember to file the original plus 2 copies of both of those documents. That way the court will have a copy and then you will have proof that you filed it with the court. That's very important. And with COVID, we've had to file a lot of things by mail or drop them in a file slot. So we've had to include a postage paid envelope addressed to ourselves so that we get our documents back. So if that's the case in your jurisdiction, make sure you do that. Obviously, if you're filing by mail, make sure you do that. But with the 5-day court day deadline on this document, this really is something that you're probably going to want to file in person because it may not get to court before the hearing. And in larger counties, you're going to want to make sure that that document makes it in the court file. You'll want to do that in all counties, but it seems like it gets to the court file quicker in small counties than it does in big counties. So again, this is not legal advice, for educational purposes only. Always be sure to research the law. It changes from time to time. So don't trust that when you're seeing this video, the 5 court days that I stated is still the case. Always go review the law. If you have any questions, contact an attorney, not me, so that they can help you sort this out. And thank you for tuning in. I hope you'll click the subscribe button, give us a thumbs up, ding the bell so that you will get notice when we upload more videos.